First things first, and most importantly, I want to thank each and every one of you all. You knew what you're getting into, and it would have been very easy 8 days ago when you saw the people throwing up their hands saying, I can't be fair, I can't presume innocence when I know somebody's been arrested before. It would have been very easy for each and every one of y'all to throw up your hand and say, man, I want to get out of this too. I'm going to say the same thing. But you didn't. And we asked you questions. And you replied honestly that you could do the very, very tough task. And that's do what nobody has done thus far. And that's presume his innocence and disregard emotion, the accident, the fatality he caused, and the prior DWIs. This is not easy for anyone. It's not easy for them. It's not easy for them. It's not easy for y'all. It's not easy for me. I can't feel my legs right now. I'm so nervous. This is so important to so many people, to the family of the deceased, to the Tarr family, to our system of justice, to all of us. But this is not about me. This is about what I know to be right and wrong, and what I know to be an innocent person. And I'm going to do the best I can to
the proper argument for counsel to give his opinion.
Your Honor, he said 100 times our client's guilty. If I can't say he's innocent.
You are interjecting your opinion into the jury as objectionable. It's been objected. The objection is sustained.
I'm going to do my best to forge ahead. As important as this is, I'm going to try to make it very simple from the start. If you're not convinced beyond a reasonable doubt that he operated a vehicle while intoxicated, you stop right there. I'm not trying to diminish the importance of the significance of this, but we are all in agreement that's the issue in the case. That's the hump that you all are faced with. And I submit to you that if this were if there was no prior DWIs, if there was no fatality he called, but with this same evidence, would you be convinced beyond a reasonable doubt such that you would return a verdict of guilty on DWI? Of course not. So you have to do the same thing armed with those facts that you're asked and you promised you would disregard. Wrongful convictions, we all know that they happen. And whenever we do hear about a wrongful conviction being overturned, it's because of DNA. And the DNA doesn't just prove...
I'm going to object. I know evidence of that. This is improper argument as well.
In what way?
That improper convictions are a result of DNA. That's had nothing to do with this case. There's been no evidence about that.
No DNA evidence in the case.
Correct.
We know that wrongful convictions can happen. But why do they happen? Why do they occur? And I submit to you, jurors and witnesses, we tend to get an emotional attachment. We tend to not be able to disregard something that the oath and the obligation of the law tells us that we have to disregard, and that's if somebody has prior convictions. But I submit to you that in each and every one of those cases where somebody's been wrongfully convicted, a prosecutor stood right here and said, we proved our case beyond a reasonable doubt. Which brings us to a recollection of some of the witnesses in the case. We don't have enough time to go over all of them. But the prosecutor stood right here just a few minutes ago and said that we, and accused us at that table, we were going to basically cherry pick. We were just going to hand pick some things and deliver to y'all and didn't want to deliver y'all the whole truth. And what I submit to y'all is, I want y'all to ask yourselves this question when y'all are deliberating and recounting the testimony. Why didn't they ask that question? Why, when Mr. Spiller was on the stand, the EMT that had the most close contact with Jason moments after the accident, why didn't they ask him if he noticed any signs of intoxication? We asked that question. His answer was, no, I didn't notice any signs of intoxication. Why didn't they ask that question? Because they didn't want you to know the answer. He stood right here and said, Ms. Heitman thought he was intoxicated. That is not testimony, that's not the evidence in the case. Ms. Heitman and Mr. Heitman testified, as did Trooper Hart. Prior to the accident, because of the bad driving, they suspected intoxication. Once the accident occurred and they were in Jason's presence and helped him out of his vehicle, and watched him walk and wrote written statements. They even told the officer he must have been texting or something. Why did they say that after the accident? Because they thought after the accident, and they knew after the accident, that he wasn't driving bad because of intoxication. We were in his presence. He's not intoxicated. It must have been something else like texting. But he didn't say that just a minute ago. He accused us of we're going to cherry pick and select what we want to. No, that was Mrs. Heitman's testimony. She seems like a nice enough lady that she wrote a statement as he did, and neither one of them wrote in their statement any suspicion of intoxication. No odor, no funny walking, nothing. They said he drove bad. They were asked by the officer. Ms. Heitman said, no, he walked fine. Nothing indicative of intoxication in the manner in which he walked. At the time, that's what she said. When she got right there up on that witness stand 2.5 years later, knowing he's got prior DWIs and being whisked around by the prosecution as part of the home team, what was her testimony from the witness stand? He had to be aided when he walked by EMT Eric Spiller, had to aid him with both hands, walking him to the ambulance. You didn't tell Trooper Hart that 2.5 years ago. You didn't say it in your statement. Eric Spiller testified, no, Jason walked unassisted and walked fine, and I noticed nothing indicative of intoxication in anything, including the manner in which he walked. And Officer Alvarez's video contradicts what she sat right there and said. You see on the video Jason walking perfectly fine, unassisted, walking with the EMT to the ambulance. Is she lying? No. Is she mistaken? Obviously, without question, she's mistaken. How does that happen? You get whisked around by the home team, you find out somebody's got priors, maybe somebody tells you about a blood test that doesn't tell you it was out of order game, and all of a sudden, she gets an emotional attachment, as do a lot of their witnesses to the case, and it affects their recollection. A nice enough lady, that's how that can happen. I'm not picking on her by any means. The individual, Mr. Bryant at the hospital, the security guard at the hospital, don't have enough time to go into everything he said. But one thing he did say is that he remembers Jason's head going like this. He can't remember anything else except the head going back and forth with the C-collar on, which is not even possible to do. Is he lying? No. Is he mistaken? Yes. Why? An emotional attachment. Mr. Spiller, touched on him. It's very important, though. The state didn't ask the questions. We did. How was he? He was fine. Did you smell anything? No. Now, when the subject of odor versus non-odor comes up, we're not saying that Jason didn't drink anything. We're saying that it was such a small amount and was out of his system to the degree that some people, many people in his presence at the scene, couldn't even smell it. Some could, some couldn't. It was that faint of an odor, meaning that little of alcohol in his system. But Mr. Spiller, in response to our question, said, no signs of intoxication. Why don't they ask that question? Their witness. The state tried to rehabilitate him for their purposes. He was honest, they don't need to rehabilitate him, but they tried to rehabilitate him for their theory of the case. Oh, well, if you're looking for treating somebody, you're not looking for intoxication, are you? No. Well, that's such an absurd proposition, it doesn't even dignify a response. But I'm going to give you one nonetheless. A medical professional, fully attentive to the person's needs, their senses, their body, their mind, their eyes, their tracking, their speed, everything. If anybody in the world is going to notice signs of intoxication, it's Eric Spiller, the EMT. And for them to say that their argument is, well, because he was focused on this, he's not going to notice intoxication. That is absurd. If you're looking for medical reasons, they're the ones that are diagnosing somebody for medical purposes. You're the very first person that's going to notice signs of intoxication if they were present, which they weren't, and he didn't notice. Prosecutor stood right here and said, Officer Alvarez thought he was intoxicated. What he didn't tell you is the rest of the story. Officer Alvarez, the evidence is shown through the witnesses and the testimony. He told at least 2 different officers on the scene that Jason did not smell like alcohol. In response to Trooper Hart's question, Officer Alvarez said, no, he walked fine. And he was asked the question, how did he look? Did he seem intoxicated? Officer Alvarez told Hart, no, he walked fine. But what happens two weeks later when he writes his report, knowing that Jason has prior DWIs and has been arrested for intoxication manslaughter? Does he bother to write his report? I didn't smell alcohol. I told 2 officers. He walked fine. I didn't see any signs of intoxication. No. Why? Because the die was cast, ladies and gentlemen. That's what this case is about. When they found out he had 2 prior DWIs, even people that had no motive at the time, like the Heitmans, it affects people because they become emotionally attached to the home team when they find out that information. And the officers are no different. Now, what the prosecution just said is that Dr. Kitlowski thought Jason was intoxicated, and that's all he said about Dr. Kitlowski. What the evidence reflects is that in his medical report, Dr. Kitlowski wrote intoxicated. When we ask the question, can't that mean something as simple as you smelled alcohol and you write intoxication even if they're not really intoxicated? His answer is yes.
Objection, Your Honor. That is the opposite of what he testified to.
The jury is the fact finder. They'll remember what the doctor said.
His testimony was just that. The judge said y'all can recall the testimony. His testimony was just that. So why abundance of fairness? We're obviously prepared for this trial. We want the jury to know the answer to this question. Can intoxication that you write in your medical notes mean something less than the legal standard? Can it mean something as simple as he smelled like alcohol? The answer is yes. They didn't ask that question, did they? Trooper Hart, minutes after arriving, he and Deputy Carranza are already talking about a blood search warrant, with admittedly no probable cause to believe Jason was intoxicated. In fact, Trooper Hart had been told by other officers no signs of intoxication, by interviewed civilian witnesses that wrote statements and said no signs of intoxication. The state is going to argue that Jason's confusion in the back of the ambulance about the directions when he had to lean, and when he did, he said, yeah, officer, you're right. That is the direction, correct. Now that I can see out of this box, correct. And that is where their testimony stems from, and their evidence. He's so confused that he must be intoxicated. But that's not what Alvarez thought at the scene. At the scene, he thought he was not intoxicated until he found out he had prior DWIs. But Hart is talking to Lashley, not relaying all these signs of sobriety that he knows about, not relaying any signs of intoxication. He's simply relaying, get a blood search warrant. This guy's got prior DWIs. Where there's smoke, there's fire. That's what jaded and guided these officers' investigation, if you want to call it that. So at that point, the die was cast. These officers know he has prior DWIs, and they develop tunnel vision. Enter the testimony of Trooper Sadler. What did Trooper Sadler say that was significant? Quote unquote, Lashley was going to the hospital to get probable cause of intoxication. That's what Lashley was doing according to Trooper Sadler. That is very significant because the evidence and the testimony shows they had no probable cause to believe he's intoxicated. The officers, the other troopers had testified, no, we weren't jumping the gun. When we ordered him detained at the hospital, it was for an investigation of criminally negligent homicide, not for suspicion of DWI because we didn't have intoxication facts. But Trooper Sadler came clean with what really happened. Lashley was going down there to get probable cause of intoxication so that he could go present it to a municipal court judge and read the paper and get a warrant signed to get into his body for blood. That's significant because Lashley, when he got down there, no recording of Jason, nothing. It's just, from now it's just, hey, believe me, ladies and gentlemen of the jury, here's what I found. Now, if he's going down there to find probable cause, don't you think he's going to testify like he just did about what his findings were? He's using terminology about sitting on him, detaining him, not letting him leave. If he doesn't cooperate, I'll treat him as a hostile witness. We're getting a blood warrant. Any facts of intoxication? No. Trooper, did you have probable cause for intoxication? No. And he's still doing all those things. The die was cast. So not surprisingly, when he does this HGN test, which by the way, H stands for horizon, which means this. Laying on the ground, by definition, waving around in front of somebody or hanging over them, and then looking up, by definition, it's not the horizon, it's not horizontal.
Objection, Your Honor. The word is horizontal, not horizon.
The jury can, never mind,
I'd ask the record to reflect that Mr. McNabb's motions were horizontal both times he demonstrated it.
So reflect. Dr. Platt testified. He's the expert. He's the one that trains officers. He's the one that ran the program for the state of Texas. He left because he didn't feel comfortable with what they were doing. Voodoo science that wasn't based upon any facts or data. And he says, I don't feel comfortable with this. I'm gone. So what does he do when he testifies? Dr. Platt said, when you lay down, it alters your vestibular mechanism in your makeup. That's why it has never been a standardized test. Okay? The trooper alluded to some sort of study. Well, some sort of study said we can do it. Did it prescribe a standardized method? Because remember, standardized field sobriety tests have to be standardized. Is there any standardized method? No, but there was 2 studies done. Oh, so one of them was 10 years ago done, and one of them was 15 years ago done. Yes. Well, in the 10 and 15 years since this study that you're referring to that says, okay, it's okay to do it on somebody laying down, has NHTSA, the authoritative source, put it into a manual with a standardized method like is required of all the other tests? No. They've had 10 and 15 years to teach the officers with a standardized method it's okay to wave it around to somebody who's laying down. Have they done it? No. Why? Because you can't. There is no standardized method prescribed to do the test. So is the trooper going to see, under those circumstances with a die cast and knowing what he knows about this, clues and that person's eyes bouncing? Of course he is. Now, Dr. Day testified in response to our questions that she checked Jason's eyes as part of her protocol whenever he was admitted into the ER, which included him tracking the stimulus from side to side. Did you notice some stagnance, Dr. Day? No. Did they ask that question? No. Why? You know the answer why. They didn't ask that question. So Dr. Day, she said if she had noted when she was doing eye tracking on a patient in the ER, not trying to arrest anybody, if she had noticed it, she would have written it in her report. Did she write it? No. So was it present? No. By an objective physician witness. And even if this bouncing of the eye is present, so what? So what? I mean, they didn't tell you what that means. Some innocuous reference to it's a reliable before he ever got to the hospital to do the test. So enter Tony Ortiz, their expert breath test guy from the same entity, the police lab that employs the same officers that are making this case against Jason. Ortiz works for the same crime lab. And Ortiz, he testified that, well, how did it happen? Mr. Ortiz, we've got a problem with our case. We've got police officers and civilian witnesses that are all saying there's no signs of intoxication on Jason after the accident, shortly after the time he was driving. Come help us. Come help us. Get us out of this mess. Ortiz, no problem. I'll come in and create this temporary door of sobriety, and I'll attribute it to adrenaline kicking in when you're in an accident. But don't ask me any other questions, prosecutor. Don't ask me to explain anything physiologically. the human body, how it works, what chemicals or compounds it negates this adrenaline to cause a person to go through this temporary door of sobriety. Why did they do that? Because at the time of the accident, he looked and sounded fine by all accounts, police officers included. And they had that problem with the case because that's the relevant time. Not what Lashley noticed before he ever got to the hospital and had made up in his mind. Blood test. There's problems with the lab. They are the bottom feeders of the scientific community. They employ a single point calibration curve.
Objection, Your Honor.
The testimony was,
What's your objection?
Objection to characterization. It's improper. Calling them bottom feeders.
Calling people's name is not proper. Let's avoid that.
my apologies, Your Honor. Disregard that, jury. They don't use the scientific method that other scientific labs use, which is a multi-point calibrator. That is one of the quality controls that you ensure the integrity or the validity of this. And we're talking about a person's freedom. We're talking about a lady that lost her life, and that's the best they can do. It's the lowest thing, the lowest rung of any scientific community. And getting the batch out of order. And he coming in here with that plausible excuse to try to explain it. Look, the reasonable thing to do is to put those vials in order and retest the batch. He said it takes 10 hours to run a batch. That's like me saying it takes an hour for me to wash clothes. No, it takes me 30 seconds to stick it in the washer and I walk away and the washing machine does the work. And this machine is the same way. But he didn't want to sort the laundry out, take the whites and the colors and the delicates and sort them out. So he just started getting out his pen and started scratching through stuff instead of redoing it. Mr. Cautious, Mr. Salinas, putting on rubber gloves in court to look real professional and real cautious, who said we overdo everything at the lab. That was his testimony. And who said that this error was so obvious that anybody would have seen it. Did he see it? No. It was caught by somebody else 4 or 5 days later, the error that he made. What does he do? Mr. Cautious, Mr. We overdo everything. Certainly he goes back and puts those vials in the correct order and hits the button and retests it, doesn't he? No. He just starts scratching through things. And 2.5 years later, they come in with some excuse to explain why he didn't redo the thing. Burden of proof beyond a reasonable doubt to rely upon that scientific evidence. Would you trust that lab? When he thinks that 9 plus 7 is 17, when he got asked twice in a row and had to be corrected, would you trust the most important of your affairs to that lab? Something that had to be proved important to you beyond a reasonable doubt? Of course not. And that's what they're asking you to do. Just disregard that. And as far as the blood test is concerned, how does it really work? If you can't explain the way the blood test works under gas chromatography with a degree of certainty, you can't explain it to somebody else when this trial's over, your neighbor over the fence. Oh, blood, really, how does it work? Well, here's how it works. If you can't do that, you can't use it to convict. And I submit to you, here's why. There's only one presumption in this courtroom. And it's not that blood's accurate. It's not that the sun will rise in the east. It's not death and taxes. There's only one presumption, and that's innocence, period. And if you can't explain the way the blood test, gas chromatography works to somebody else, to the degree that they can tell somebody else how it works, then you would be violating or asked to violate the law, because there's only one presumption. If you can't explain it, you can't rely on it. You're presuming it's accurate. Now, that's not your fault. It's not my fault. It's theirs. They have the obligation to educate you to the degree that you're not just assuming and presuming that it's accurate, but that you can explain why it's accurate or how it works. Your oath. Presuming somebody innocent until the state proves their guilt beyond a reasonable doubt. I submit to you, that requires you to challenge their evidence. It doesn't require you to accept it. It doesn't allow you to accept their evidence at face value as truthful. It requires you to say, I'm going to challenge your evidence until you convince me otherwise. Their blood test in this case is tantamount to flying the soup. You took a lunch break today. You go down to Garcia's down the street. You order tortilla soup. You find a fly in your soup. What will they do? Well, they'll take your bowl, and they'll take mine, and they'll take his, and they'll take hers. And then everybody who's got the soup, let's get it off their table. Let's get back to the kitchen and get that pot from whence this soup came, and let's dump it out. That's the safe thing to do. That's what the health code would require a restaurant to do. What does DPS do when there's fly in this soup? Problems with their batch and their methodology? They don't even bother to reach down and take the fly out with a spoon. They certainly don't take the bowl away. They don't take yours. They don't take yours. They don't go back there and pour out the entire pot to ensure that all these other citizens who are mixed in with this mess are not also wrongfully convicted. They just sat there and hoped that we don't catch it. This dumb country lawyer that can't do a PowerPoint has to look at his notes. He won't catch it. That's what they're hoping. Bad driving. We know inattentiveness can be caused by something besides intoxication. There's laws that say thou shalt not text when operating a motor vehicle. A horrible accident happened outside of Concan last month. Horrible accident. Individuals followed for 20 or 30 minutes all over the roadway. Killed 12 or 13 people that were doing a benevolent thing for a church.
Objection, Your Honor. There's no evidence of any of this. This has not been brought in.
We may be normal community knowledge from the press, so
Your Honor, I'm unaware of it. I don't think you can just cite what you read on the internet or something and ask the jury to believe that that's happening.
your objection is overruled, counsel.
We know that something besides intoxication can cause bad driving and inattentiveness. But they have to prove, we don't have to prove that he was texting, or that he was nodding, or that he's talking on the phone, or typing on something. We don't have to prove that. They have to prove it was intoxication beyond a reasonable doubt.
5 minutes, counsel.
Thank you, Your Honor. Them detained criminally negligent homicide. Now, I submit to you the evidence showed that's really not what they were doing. They had their mind made up. They were going down there to draw blood on a case they had no intoxication suspicions about. They were going down there to draw blood. But let's go with what the trooper said. Criminally negligent homicide. So by you returning a verdict of not guilty, you're not rewarding Mr. Tarr. You're not giving him any cause for celebration. He's going to carry this, every one of us is, probably for the rest of our lives. What you're simply telling the prosecution is, charge him with what he did. Criminally negligent homicide. Don't ask us to do your dirty work for you. Don't try to sway us with emotion because of fatality and smoke and mirror us into a conviction because he has prior DWIs. By returning a not guilty verdict, you're saying prosecution charged with what he did. And there might not be a trial next time. Justice. When they talk about justice, I submit to you, justice they're seeking is revenge. That's all it is. Because when we talked about these witnesses that they called and they wouldn't ask questions about, and they stood here and said something entirely different than the witnesses testified to, that's not justice. Lady Justice, as the judge told you, and we all know, holds the scales equally in front of her. Blindfolded. Blindfolded. But when you start getting these things entered into your persuasions about emotion, and you hear about a fatality over and over, and the death, and the accident, and he drove bad. Look, convicting a person of the wrong offense because he did something bad, that's not justice. And I submit to you that an injustice anywhere is a threat to justice everywhere. I'm going to ask you to do what nobody's been able to do in this case so far. Before I do, I want to, one last thing about the integrity of the blood sample. The lab submission form that was submitted to the lab, an objective lab, contained information criminally negligent homicide, which is not relevant to the blood scientist analysis. He tried to run from us on the lab notes where they're supposed to write things like collections and things like that, and we had to poke him twice, and notes relevant to the collection of the blood. They're writing in notes to the supposed to be an objective person doing the blood test about the facts of the case. And doing that to the vial is going to cause thank you, Your Honor, will cause a falsely high alcohol concentration being reported. And Mr. Cautious sat right here with his gloves on and shook the vial in front of you. Do you think that couldn't have happened at the lab?
Objection, Your Honor. There is no evidence that happened at the lab. Absolutely none.
They can make reasonable
The jury knows what the evidence was they heard of.
I'm going to ask you to do what nobody's been able to do in this case. I can't give you the strength to do what I know is the right thing, and that's to find him not guilty of discharge. It's going to take courage. But you're only human, as were the officers and the witnesses in the case. Start getting persuaded by emotions and emotional attachment and stuff, and you lose sight of, wait a second, they have to prove beyond a reasonable doubt intoxication. No one else has been able to do it so far. No one, even good people that testified. I'm going to ask you all to do the seemingly impossible task, and that's just that. Not be swayed by the priors and the emotion, but to hold the state to the burden of proof beyond a reasonable doubt. Nobody's done it before. So when I get asked the question, is it hard to defend somebody that's guilty? No, that's easy. What's hard is defending somebody that's innocent. Thank you.